morning, everyone. Can you hear me? Good, good, good. Welcome to the November session of the Court of Criminal Appeals in the Eastern Division. Let me first begin by introducing the panel. To my right is Judge John Campbell from Germantown, Tennessee, from the Western Division. To my left is Judge Tom Greenholtz from Chattanooga, Tennessee, from the Eastern Division. My name is Camille McMullen, and I am from Memphis, from the Western Division as well. Madam Clerk, well, before I do that, again, I see some very familiar faces in the audience, but let me remind you, each side gets 20 minutes. As you approach the well, let me know if you would like to reserve rebuttal time. We will try to keep up with that, but pay attention to the light system. Madam Clerk, I do not believe we have any preliminary matters, do we? All right, well, we'll hold that until that case. Other than that, all right, thank you, Madam Clerk. You may call the first case.
State of Tennessee versus Russell Matthew Morgan.
Good morning, Your Honors. I'm Bob Jolly of Knoxville. I'm here representing Russell Morgan in a Monroe County case. The first issue we would like to address is an issue concerning a picture. That issue is in the record.
Did you say a picture?
A picture. Yes, ma'am. The picture is...
Mr. Jolly, did you want to reserve any rebuttal time? Excuse me for cutting you off.
Your Honor, I hope I wouldn't need it, but 5 minutes would.
All right.
The picture is of Mr. Morgan without a shirt, with a belt that is tightened, and some pubic hair showing. And as I told General Redding this morning, that I was raised in a town with a public swimming pool, and half of the teenagers at that pool who were close to 17 or 18 would be guilty of lascivious and patently offensive display of a pubic area under the ruling of the court in this case, affirming the conviction. This is an issue that the court needs to look at. The statute talks about simulated sexual activity. This picture is certainly not simulated sexual activity. It was in fact sent in the course of this social media conversation on March the 5th, even though the indictment alleges these acts occurred on March the 6th, which is prior to the time that there was any explicit language or discussion of sexual activity. The second issue that I would like to address concerns the sufficiency of the first count of the indictment. This count alleges a violation by Mr. Morgan of 3913-528, which was specifically enacted by the legislature to determine and allow the use of police agents to talk with people on social media concerning sexual offenses. That statute still provides the following language. It is an offense for a person 18 years of age or older by means of oral, written, or electronic communication to induce a person whom the person making the solicitation knows or should know is less than 18, or solicits a law enforcement officer posing as a minor and whom the person making the solicitation reasonably believes to be less than 18 years of old. And the discussion of that probably supports this. But it says that you must engage in a violation by the soliciting adult of one or more of the following, and part number 7 of that says statutory rape pursuant to 3913-506. When this statute was enacted, there was only one statutory rape. Since that time, the legislature has divided 3913-506 into 3 sections, one of which says mitigated statutory rape, one of which says statutory rape, and one of which says aggravated statutory rape. The indictment in this case that was presented by the Monroe County Grand Jury says that Mr. Morgan is guilty of soliciting aggravated statutory rape, which is outside the terms of the original statute. There was an issue about a misstatement or a mistypographical error. 3915-506 was in the original indictment. There's no such offense. 3913-506C is what they refer to, which includes the current definition of aggravated statutory
The
rape.
indictment in this case was amended, correct, Mr. Jolly?
I'm sorry, Your
The
Honor.
indictment was amended, correct?
The indictment was amended to allow the change of 3915-506 to 3913-506.
Okay, and you're alleging that there is no
Well,
offense for that?
We alleged at the time. My problem is, Your Honor, is the language of aggravated statutory rape, because 3913-528, which is what Mr. Morgan was indicted for, does not include the language aggravated. And the reason why it is important is because of the potential punishment that is involved in the case. Because the statute clearly says that solicitation of an act is one step below the act solicited. And that's what 3913-528 says in Part C of that statute. So at the time that it was enacted, the solicitation of statutory rape by an adult under Section 7 was a Class A misdemeanor, because statutory rape at that time was a Class E felony. So at the time that the legislature presented this statute, and they've had opportunities to amend this statute since that time and have chosen not to, it still exists under this term. But our position is because the state chose to use the words aggravated statutory rape and use the language of subsection C of 3913-506, that was not a proper offense under the law in the state of Tennessee. Now,
Mr. Jolly, what do you make of the fact that this court has upheld solicitation of aggravated statutory rape previously?
Well, Your Honor, I would suggest that the court was wrong.
Well, the legislature, as you said, has had the opportunity to come back and change it if the legislature thought this court was wrong.
Well,
for example, I mean, Judge Easter had a holding at least as far back as 2018 in State versus Weldon.
Well, Your Honor, my problem with that portion of the language is that you are increasing the punishment that was originally enacted by the legislature in 3913-528. And you're increasing it by changing.
It's not a policy argument, it's just the language argument. It's really just a statutory interpretation argument, not a policy argument.
Well, and perhaps it is. And so the question is, what controls in subsection 7? Does the language that says statutory rape control, or does the language of 3913-506 control? So is it a violation of 3913-506, which is what the state argued and the trial court accepted, and that under 3913-506 you now have 3 sections, and they said that the state could pick any section that they wanted and increase the punishment. Our position is that the legislature said that it was statutory rape. Doesn't matter the statutory term that they refer to, but the offense itself, which is statutory rape. And the offense that was alleged in this indictment is not statutory rape, it's aggravated statutory rape. There is a third issue in this case.
Does your position, Mr. Jolly, require us to overrule all of our previous cases recognizing the offense of solicitation of aggravated statutory rape?
No, Your Honor.
I mean, how does it not?
What it would require in this case is a resentencing, because they could have taken out that aggravated language. They could have proceeded on statutory rape, and they could have, if there was a conviction, sentenced Mr. Morgan as a misdemeanor, not a Class E felony. So our position is that you could apply it strictly to this case, Your Honor, and the facts of this case. The third issue that we raised concerned the state's, the indictment in this case was obtained and the investigation was done by an officer of the Monroe County Sheriff's Department who was subsequently fired for committing perjury. And he was fired between the time that the indictment was obtained in this case and the time of the trial. Excuse me. The state was allowed to substitute an individual whose notice was not given until shortly before the trial, 2 or 3 weeks before then, saying that because she observed the conduct, she was allowed to testify about this other officer's interrogation of my client and the investigation. We would submit, excuse me, that is hearsay and not
Well,
appropriately done.
Mr. Jolly, do you agree, I mean, the state argued, well, yeah, they presented in their brief that this issue is waived because you did not include hearsay as grounds in your motion for new trial?
No, Your Honor, we don't.
Okay, well then, answer this question for me, because I was a little perplexed as to what the grounds were. What were you objecting to on this issue before the trial court?
What did we initially object to?
Yes.
I believe the statements were made concerning the substitution of Ms. Philly for
And that was a procedural
Officer
question?
Schneider.
That was a procedural question?
And the fact that she was not qualified to testify under the circumstances.
All right.
Yes.
Did your objection evolve?
Did
Your objection evolve? Did it turn into something else when the trial court rejected your position there?
I think when we renewed our objection when she was testifying, Your Honor, that we may have used the word hearsay. Now,
You may have used the word hearsay.
Now,
Is that
does it-
sufficient to preserve the issue?
Well, Your Honor, my concern is, in this case, is that if my misstatement and not use of the word hearsay waives this argument before this court, then I don't understand how the state can add words to statutes or proceed by adding words.
Yeah, I mean,
and-
that's just mixing and matching arguments. I think fundamentally what Judge McMullen, not to put words in the presiding judge's mouth, but I think the concern that she is raising is that to properly preserve an issue for appeal, it needs to be the subject of a specific objection in the trial court, renewed in a motion for new trial, and then properly presented and argued in
And-
this
and
court.
you're-
And that doesn't have anything to do with whether the state had denominated the right subsection in the statute. The question I have is also what Judge McMullen has, and that is, in the motion for new trial, there's no mention of hearsay at all. So
And
it's
we
not in
were-
the written motion. It doesn't even appear in the transcript as far as I could tell. How was the trial court judge on notice at that point that this was a legitimate issue that the trial court needed to weigh and consider before it got here?
Under that interpretation, the judge is not on notice, Your Honor.
Okay,
We would
so
say
Judge
that the
McMullen-
judge is on notice about the substitution issue,
Okay.
which is implicitly raises the hearsay.
So Judge McMullen then asks, I believe, how is it not waived here if it were not properly preserved in the motion
And
for new
if
trial?
it's not properly preserved, Your Honors have the opportunity to tell me I didn't properly preserve that issue.
That's okay.
I
That's
mean, a
fine.
bigger question,
my-
Mr. Jolly. You've been a longtime defense lawyer. Why is this not a party opponent admission? I mean, you spent a lot of time, I've reviewed the transcript here, you spent a lot of time talking with the trial court and trying to convince the trial court that this statement, which is traditionally, you agree with me, this is a
Your Honor,
traditional
I
confession.
agree with you that it's a party opponent. The statements by my client
Mm-hmm.
during the course of this interrogation are party opponent statements. The
Okay.
statements by
That's not
Detective-
what you argued before the trial court. But go ahead.
the
Because I was
statements
trying to
by
understand
Detective
where you were
Schneider are
going.
not, Your Honor.
Say that again, sir?
The statements by Detective Schneider are not.
Did you identify those statements in the brief or to the trial court? Because my position is most of those, I guess, the interaction between your client and the detective in this case, the detective was posing questions, was he not?
Concerning what his investigation has shown.
He asked questions to elicit an answer, correct?
That's correct.
Okay, and you're submitting to this court that those questions constitute hearsay?
By asserting facts in the questions, Your Honor. They're leading questions. And I understand, Your Honor, I understand
You do get
where
us,
we are.
because, I mean, I just want to understand where we are coming from. We are taking and preparing for the argument and also preparing to draft an opinion. So when I look at your brief and I look at the state's brief and then I review the transcripts in this case, I am seeking to understand both parties' positions. And your position did not necessarily make sense to me, Mr. Jolly. And so I'm taking this opportunity at oral argument to allow you to convince me why you argued the way you did before the trial court.
My position is, and I'll be realistic, Your Honor, I had an officer who investigated the case, who committed perjury in
That
the trial.
officer did not testify. I understand that you are frustrated that that officer committed perjury in an unrelated
And so
case.
you know my position, Your Honor, in that matter.
And that has no bearing on this case. So you don't have a position.
If Your Honors find that I did not properly raise it, I did not properly raise it. That's correct.
Maybe a variation on the theme, and let me see if you could help clarify an issue for me. Sometimes, at least, questions that are asked of a defendant inside of a police interview, the questions themselves are not typically thought of as hearsay because they're not offered for the truth of the matter asserted. The nature of the questions really are being asked to place the defendant's statements into a context so that the trier of fact can understand the answers that the defendant is giving and the context in which those answers are given. Is that the case here, where even if there are facts inside of the officer's questions, those facts are not being offered for the truth of the matter asserted, they're only being offered for context for the defendant's answers?
And, Your Honor, I understand that argument, and that's why every trial judge gives an instruction that we're not to be believed in the trial court, that you have to get your proof from the witness stand.
Okay, all right. Thank you, Mr. John.
But there was no such instruction given concerning Mr. Schneider.
Was one asked for? Was there a limiting instruction asked for?
It was not asked for, Your Honor.
Okay, fair enough.
Thank you.
I understand congratulations are in order, counsel. Your last name, did you get married?
No, that was Miss Renard, now
I'm
Miss
sorry.
Hornsby. But
Strike that.
she'll be here this afternoon,
do that later.
so you can convey your congratulations to her. But may it please the court, Catherine Redding, on behalf of the state. I'm actually going to address the defendant's claims in reverse order, as they're raising the brief, but starting with the hearsay claim. So the defendant is not entitled to relief on his claims regarding Detective Billy or Detective Schneider and Detective Schneider. So to the extent that the defendant has raised claims about Detective Billy, which I'm still not entirely clear on the exact nature of those, the defendant's brief claims that the state, basically he's complaining about the state's decision to use her as the lead detective, the lead witness, and the trial court's decision to let her testify in Detective Schneider's place. So to the extent that those are independent claims, the defendant's waived those claims because he's failed to explain in his brief why he's entitled to an appellate relief on those particular claims. And all of the law and the analysis that's provided relates to hearsay, which appears to relate only to the admission of Detective Schneider's interview questions and statements. He made mention this morning of hearsay statements by Detective Billy, but that is not in the appellate brief. I mean, a mention of Detective Billy's hearsay statements is included in the statement of the issues, but in the actual body of the brief, there's no identification of what statements are hearsay. And in my review, the court has this before it, but the transcript from trial, I don't see any hearsay statements by Detective Billy as to Detective, or she's conveying Detective Schneider's during comments or questions during the interview. The interview was played in its entirety for the jury without really any commentary from Detective Schneider about the questions, because that simply wasn't necessary. It's all on video. So to the extent that there are any independent claims related to Detective Billy, those are waived. As to the defendant's claim that the trial court erred by admitting certainly this was litigated in the trial court. It is briefed in the body of the brief, but it's not in the statement of the issues. Saying in the statement of the issues that Detective Philly's testimony was hearsay is not the equivalent of saying that Detective Schneider's interview questions and statements were hearsay. But more importantly, the defendant made this claim because, as this court noted, it's not in the motion for new trial. The defendant did file a motion for new trial, raised several claims. The only claim that is not related to either the indictment, to the sufficiency, or the sentencing is a claim that the state, that the trial court erred in allowing Detective Philly to be added as a trial witness. But again, that does not translate into the claim that Detective Schneider's interview questions and statements were hearsay. And because it's also clear from, I think as the court noted, that the hearing testimony from the motion for new trial hearing also suggests that a hearsay claim was not developed at the motion for new trial. And it's the failure to include it in the motion for new trial that results in waiver. And so the only review that is available to the defendant is plain error review. But the defendant has not acknowledged the waiver and says actually that it was raised, but it's not waived. So he also has not, so he's not acknowledged the waiver, has not requested plain error review, and has not engaged in any plain error factors. And this court has issued many opinions recently discussing if a defendant doesn't request plain error review, why should the court grant review that isn't requested? And so under the case law...
Well, I mean, absent extraordinary circumstances.
Yes, and I think that in this circumstance, especially when we have, it's not necessarily a failure to recognize the waiver, it's a position that there is no waiver, so plain error review is not necessary. So under these circumstances, it's the state's position that this court should not engage in a review that the defendant has not requested. So unless I have gone into plain error factors in my brief, unless this court has any questions about them, I'll rely on my brief for those.
So, General, the argument that that your friend on the other side raises that is of interest to me relates to the enactments of various statutes. And so what I understood your friend on the other side to say was that at the time the solicitation statute went into effect, there was simply a statutory rape statute only that could be referred to, that it didn't include a mitigated statutory rape or an aggravated statutory rape, and that those provisions for aggravated statutory rape were added after the solicitation statute had been enacted. I understand his conclusion to be then that to the extent we look to legislative intent, I'm not advocating that at all, but to the extent that we look to legislative intent, his argument, I believe, is that the legislature could not have intended, the enacting legislature could not have intended aggravated statutory rape to be a predicate offense. What's your best argument to that?
I think my best argument is that, yes, the legislature did change, but the legislature has had an opportunity in all of the years that have passed since then to go in and make changes. And this court, as you pointed out, this court has issued several opinions where it's upheld convictions for solicitation and aggravated statutory rape, not to get into all of the other canons of statutory construction. But I think, given the amount of time that has passed, this legislature had ample opportunity to go back in and amend this solicitation statute if it felt that the language, the general language that it used in that statute was did not actually encompass it. So I think, it's the opposite side of the coin, right? So the defendant's arguing, well, things changed and they didn't go change it. They didn't go amend the statute, so we can infer that it only intended to apply to statutory rape under...
Let me interrupt you for a second.
Yeah.
Mr. Clerk.
Oh my goodness, sorry.
Thank you so much, sir.
Well, let me ask you this, unless we need to take care of the microphone issue.
It's working now.
Okay. This is my problem with taking legislative intent generally, and the case law that talks about trying to discern the intent of the legislature doesn't work as well as some of the more recent cases from the Supreme Court, where we focus on what a reasonable person would have understood the language to mean at the time of its enactment. So if we have essentially a reasonable reader construction of statutory analysis, we do seemingly have here kind of a mix match here, where we have statutory rape on the one hand being referred to in the statute itself and not aggravated statutory rape, and then a general citation to the statute that now includes aggravated statutory rape. I understand your friend on the other side to say, well, it's a choose your own adventure. Which one do you want to go with? How does the reasonable reader understand then when it seems like the statute's pointing in two different directions? Does the reasonable reader conclude that there's an unresolvable ambiguity and that push goes to the defendant?
No, I don't think so. And I think it requires us to take a step back to the beginning of how we engage in statutory construction. And I think that you have to look to the plain language of the statute. And I understand that it just says statutory rape, but it doesn't say just statutory rape. It says statutory rape pursuant to 3913-506. And it's that second part that allows us to understand what the first part means. And the canons of statutory construction are very clear that we have to give full effect to everything. We can't ignore certain parts and just focus on one. And the defendant's position on how we should interpret statutory rape pursuant to 3913-506, it would ask us to, in this court, to ignore many of the canons of statutory construction.
Let me push back just very gently on that. I mean, part of the reasonable reader construction of statutory interpretation is what would the reasonable reader have understood the statute to mean at the time of the enactment. And I take it from that, and I believe this to be true, the statutory language doesn't change over time, because we're fixing the moment in time at which the meaning is ascertained. If the meaning was ascertained at the time when there was only a statutory rape section and not an aggravated statutory rape section, how does the state get to the point where the language can evolve over time simply because the statute has evolved over time? The original meaning was fixed at the time of enactment. How is it evolving over time now?
Well, I think the original meaning was fixed on whatever the definition is in 506. So I think that...
Even by adding new crimes?
I believe so.
Okay, how?
Well...
Because the other parts of the statute do reference aggravated sections of other statutes where those statutes exist.
Yes.
And I understand. I mean, like with a lot of aggravated statutes are contained in their own separate contained statute. So I understand that. Here the legislature has added different crimes to the statutory rape section, but at the same time didn't amend the predicate offense list here and kept it as statutory rape as it originally was and could only apply to, I guess, in 97 or 98 when it was enacted. How does the language change so that we can add new statutes?
I really think that it is the general nature of the citation to 506. If the legislature, and the fact that the legislature has had opportunities to fix this or to make some sort of change. And I think that you can't, the canons of statutory construction have to all be taken together, right? So when you look at what every word in the statute is presumed to have meaning and purpose and should be given full effect. So a construction of 3913-506 to mean all three forms of statutory rape. Yes, they have been added later on, but that is the best way to give that phrase, the statutory phrase, its full meaning and effect.
Can you give it full meaning and effect when you're ignoring, not that you are ignoring, when a reader ignores the first part, which says statutory rape
And I want to give
contained
you...
into 506?
I don't mean to
I'm sorry,
cut you off,
Judge. I'm sorry.
Answer that, and then I would like, in the interest of time,
I'm sorry,
if
yes.
Judge Greenholz doesn't have any more questions on the statutory interpretation question.
I have lots more.
No, you have lots of... How did I know that? No, I don't want to cut you
No,
off,
that's-
but I do want you to be mindful that I want to hear your argument on Mr. Jolly's white issue on the photographs that were admitted. Go ahead, Judge.
Why don't we proceed? I think you and I think understand maybe I understand where the state's position is on that. So if you'll address the presiding judge's question.
Sure.
Thank you.
I think the argument that counsel has made today in terms of his sufficiency claim is a claim that the photograph does not qualify as lascivious. The state is not arguing that this is simulated sexual activity. It falls under the other definition. So viewing the evidence in light most favorable to the state, a reasonable jury could find that the defendant displayed a photograph containing sexual activity defined as lascivious exhibition here of the pubic area. So the photograph in this case, the court will have an opportunity to look at it. clearly depicts the defendant's pubic area. So,
Well, really?
yes.
I have reviewed the photograph, and it is respectfully a hairy-chested man with his pants showing what I guess council will characterize as the V area. It is, I mean, some of the children these days wear their pants showing the back and the front. I mean, you know, as a regular sort of kind of thing. So
I understand.
I'm not being articulate, but in this circumstance, he did not reveal his genital area.
No, and that's not required. I mean, under the statute, lascivious exhibition of the pubic area is not, and so I think there's a distinction between the pubic area and the actual genitalia. So the state's not arguing that he actually displayed his genitalia. We're focused on the display of the pubic area. And I would push back on
So are we going to capture all these other kiddos that are running around here with their pants hanging down?
No, I don't think that this statute covers somebody wandering or walking around in their everyday occurrence where their pants are hanging low. And perhaps we see more than we would care to.
We do see more than we would care
But
to.
in this situation, in this photograph, we are seeing more than simply areas we wish we hadn't seen. I admit that the photograph does depict the defendant's entire chest, but it goes further than that. And I would argue that a focal point of the photograph is his pubic area, and not just some, but several inches of his pubic area. And
Well, I mean, the focal point, you get that from the fact of the direction of the picture being taken from above, and the fact that the pants are intentionally pulled down rather than maybe as a matter of just dress, but here purposefully pulled down, the photograph taken from above.
yes, and so part of it is that the defendant's not engaging in everyday activity that would ordinarily be performed nude. I mean, he is posing for the photograph in what the state would argue is a provocative manner. He has intentionally exposed his pubic area, not merely because he's wandering around and his pants are hanging low, which I would not wish for the statute to capture unintended sartorial choices. But in this situation, we have a defendant who has pulled his pants extremely low, past what I would argue is colloquially known as the V. We have several inches, and there's a clear distinction due to the defendant's grooming. You can tell that we are looking at multiple inches of his pubic area, significantly lower. Just simply because his pants are still managed to be buttoned does not mean that it is not a lascivious display of the pubic area. And given the angle of the photograph, Judge Greenholz, as you pointed out, I think that a focal point, yes, he is showing his chest, but that is not what this photograph is designed to capture. He is posing to take a photograph of the multiple inches of his exposed pubic area so that he can send this to someone he believes is a 14-year-old child. So this is not something that, I mean, given it's not just the nudity, it's the pose, it's the positioning, and that's what was talked about in White Ed too. There's more than just a display, and so taking everything about the photograph together, a reasonable jury viewing this evidence in the light most favorable to the state could conclude that it was a lascivious exhibition of the pubic area, and so more than just someone whose pants are maybe lower than their mother would prefer them to be in public. Unless this court has any other questions about the sufficiency of the evidence, the state would ask this court to affirm the judgments of the trial court. Thank you.
Mr. Jolly. Thank you, General.
Your Honor, I'll be brief. The hearsay is within the court's consideration. My concern, one, maybe it's because of how old I am when I look at that, and I
Hearsay,
think,
sir, is that what you're referring to?
no, the picture.
The picture. I didn't know if I heard you say that you were going to go ahead and concede that it was waived based on the argument.
Well, Your Honor, I understand that the court will find that it's waived. I'm not.
Yes.
I've been at this a long time. So,
We know. You're going back to the photo.
So I'm going back to the photograph, Your Honor.
Okay.
And maybe that's part of I've been at the waiver issue a long time, but I've also been observing in the public a long time. And if we are saying, and I don't do this, but the only way you can have a selfie that you take that encompasses your whole body is to shoot down. So that's a selfie.
So these
Maybe
questions,
And-
you should ask first.
No,
Okay.
I mean, but that's the state's point though, right, Mr. Jolly, is that to capture the whole body, with the focal area being this argument, I tell you, capturing the pubic area. The only way to do that is to take it from above, and that the state argues that tends to suggest that it is for a lascivious purpose, or at least that a reasonable jury could find that it was.
Well, I think there's more to the state's argument than that, Your Honor, because if you look at the history of fashion magazines like Vogue and Cosmo and all of these things, when they are taking pictures of young male models in new outfits and where you wear your belt and what is exposed at the time you wear your belt, or female models when they're talking about having sheer blouses that obviously display what is under those blouses or those pants. And we are publishing these in major magazines. We go back to what Potter Stewart said. You know, you look at it and you decide what it is, but the question is this lascivious? And the answer is no, because otherwise everybody who ever posed as a model in any of these magazines for a history of, I guess we'll go back 65 years, I'm a little older than that, we'll talk about that, is guilty of this display and would be punished in Monroe County for the sale of these publications. And are they patently offensive? You know, heaven forbid that my grandchild would send a photograph like that to anybody. But, you know, social media has changed the way we exist. And we would suggest that the photographs do not depict genitalia. We would suggest that the state is arguing for a broader interpretation of pubic area than is warranted under the statute, because otherwise, anytime you take a football player who is sitting on the sideline with his legs apart and being treated for the area, you may have a lascivious display of a pubic area, because you can determine what is in that area if you're looking for it. And do we have to look for it, and is that intended in these type of photographs? You know, yeah, my client was wrong in what he did. You don't need to get on the media and to say what he did, be it to a 14-year-old or somebody else. And he's being punished like that. But, you know, my client is slow. And it's obvious in the record that he's slow. And he's on 6 years probation, has already done 6 months in jail because you couldn't get an appeal on a case that it is our position is a misdemeanor, and that he is being punished for being targeted by members of the Monroe County Sheriff's Office. And before any of this language comes up, they exchange pictures. They send false pictures to him, and he sends a picture that is a selfie and is no worse than many selfies I've seen. So we would ask
Thank
the
you,
court
Mr.
to
Jolly.
look at it.
Appreciate the argument
Thank you.
from both General and Mr. Jolly. We will take the case under advisement. Give us about a minute to call the next case, Madam Clerk. Okay, go ahead and call the next case.